how the child custody process works in Massachusetts, forms, timing, and emergencies. Most parents are not confused about wanting custody. They're just confused about what to file, what happens next, and when something actually counts as a true emergency. Hi, I'm Lindsey Egan, owner and founder of Poppy Legal Group. I help people across Massachusetts navigate things like child custody and co-parenting issues when real life gets complicated. And we all know it does. And today, I want to talk you through how the custody process actually works, including things like forms, timelines, and when emergency custody may be appropriate. If this kind of explanation is helpful, follow along. I try to make this process feel less overwhelming and more manageable. So, how do custody cases usually start in Massachusetts? Custody cases usually begin in one of a few different ways. They may come up during a divorce. They may be part of a paternity case for unmarried parents, or they may start on their own when parents need a court order in place. Here is the direct answer to the real question behind this. Yes, custody is never 100% guaranteed, and it is never permanently ruled out. Custody orders are always subject to re-examination if circumstances change and someone files the proper request. Courts assume that children grow, parents' lives change, and what works or worked at one point may not work forever. That doesn't mean that custody is unstable or constantly just up for grabs. It means the court keeps jurisdiction, so it can step in if reality shifts in a meaningful way. The starting point matters because it affects which forms are required, what issues the court can address right away, and how much groundwork has already been laid. Child custody forms in Massachusetts. This is where people often get overwhelmed, and for good reason. Custody cases involve specific court forms that outline things like who the parents are, what custody arrangement is actually being requested, where the child lives, and what schedule is being proposed. Filling the correct forms and completing them accurately matters more than people realize. Here's the explicit part. Some forms routinely trip up non-attorneys, and some really are risky to complete without guidance. Forms that commonly cause problems include the actual complaint for custody or complaint for modification, the affidavit of care and custody, the financial statement. Ooh, that's a tricky one, especially income attribution and expenses, and knowing which financial statement to file. There's more than one. Proposed parenting plans that contradict other filings. Forms non-attorneys fill out need to be done with such due diligence and extreme caution, especially financial statements and anything that requires sworn factual assertions. Errors on these forms can be used against you later and are so hard to undo. This isn't about intelligence. It's about understanding how courts read these documents and how inconsistencies affect credibility. Shared legal custody and how it works in practice. So, shared legal custody means that both parents share decision-making for major issues, big ticket items like education, medical care, and religious upbringing. It doesn't mean the parents agree on every small thing. That rarely happens, right, in reality? but it does require at least a basic ability to communicate. Courts look closely at whether shared legal custody is actually realistic. Sometimes it's not just whether it sounds good on paper. So, custody cases involving unmarried parents, a little bit different. Custody laws apply whether parents were married or not. For unmarried parents, establishing legal rights and responsibilities is often the first step before custody arrangements are finalized. Here is the clear answer. No, this is not usually a very long process by itself, but establishing paternity and parental rights can be straightforward if both parents are known and involved. Delays usually come from disputes, lack of cooperation, or missing information, not really from the law itself. Once legal parentage is established, the court is going to apply the same standard as it does in every custody case, which is, say it with me, what is in the child's best interests. Being unmarried doesn't reduce a parent's importance or role. What matters is involvement, consistency, and the child's actual experience with both parents. Emergency custody orders in Massachusetts. Emergency custody is reserved for emergent situations where a child's safety or well-being is at immediate risk. These orders are not meant for routine disagreements or simply just some scheduling issues. Courts take emergency requests really seriously, but they also expect them to be supported by clear facts. Knowing when emergency custody is appropriate can definitely prevent unnecessary stress and delays. So what actually happens after filing? Once paperwork is filed, the court may schedule a hearing, order mediation if that's something the parties are willing to participate in, issue temporary orders, or move the case towards negotiation with some feedback. Not every case goes to trial. Most actually don't. Many resolve through agreement once expectations are clear. The process is flexible, but the structure does matter. Custody cases can feel overwhelming when the process is unclear. I get it. Once you understand, though, how things start, what forms matter, and how emergencies are handled, the unknown feels more manageable. And clarity can help people make those better decisions, being more informed. So if you're trying to figure out where your custody case sits and what steps actually make sense next for you, for your situation, for your kids, you can absolutely book a consult online. We will walk through your situation, explain your options, and help you move forward with the confidence that you deserve.